Alex here with part 128 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off with the, I believe it was the order on contempt. That's right, that's what it was. And now we're going into the other case, the writ petition case, and we're going to go through the judge's order denying a motion for judgment on the pleadings. Again, this was a case that was transferred to my family judge, District Judge Chuck Weller. Once the case was transferred over, he reviewed my motion for judgment on the pleadings and denied it. He didn't really use a point of law. He just said that he thought it would be more fair if my ex was given an opportunity to show up in court and I guess present oral arguments in her defense as to why she accused me of being a perpetrator of DV. I have suspicions about this. Number one, I strongly believe that self-representation bias came into play. I think that if the roles were flipped, if the shoe was on the other foot, and I was her and she was me, in other words, I was the one claiming DV who had an attorney, and she was the one claiming that it never happened, and she was representing herself, I think that he would have granted it. That's just one of the things about self-representation bias is sometimes the person who has the attorney gets a few extra breaks. The other person who's representing themselves, they're treated with suspicion. The other suspicion that I have is the law itself. The way that he said it wasn't as fair, and the approach that he took, which was to allow her to sort of come and present her arguments at a hearing, there's issues here. You could be prejudiced, and what I mean by that is disadvantaged if a judge allows somebody to do this. If she shows up in court and she starts raising defenses that I didn't expect, or raising allegations or accusations that I didn't expect, it's not fair to me because we're in an evidentiary hearing and I haven't been able to conduct discovery or ask witnesses to appear and testify on my behalf, stuff like that. Now, he could just say, okay, she's raised all these allegations. He probably wouldn't offer it to me, but if I raise the objection, he would say, Mr. Falcone's correct, we need to set this in the future, which would just drag it out for another 3 to 6 months. And then if there's discovery, it would drag it out for almost a year, probably, because there would be a 3 to 6 month period for discovery alone. In any event, these are just some thoughts that I had after the fact. Again, guys, this is something you should be cautious about if you have a judge, especially a family judge, because they're the ones that typically do this kind of stuff, who says they want to be more fair, so they're going to ignore the rules, they're going to ignore the law. Just keep in mind that when they do that, it can disadvantage you, it can prejudice you, and you have to, object. If he followed the correct procedure, well, in this case, he would have had to rule in my favor. But let's just say if my ex followed the correct procedure and she raised certain defenses and allegations in the paperwork, for example, if she filed a response to my petition claiming all these things in writing, that would give me the opportunity to say, okay, she's accusing me of these 4 different things, so I need to get these witnesses to testify on my behalf, or I need to get this documentation or this photo evidence or video evidence, stuff like that. Or I could even say, I need to get to the bottom of this so that I can prove my case. I need to ask for discovery. But the way that the judge handled it in this situation didn't really give me any of those opportunities. He just said, let's just have her show up in court and talk. In any event, I think at this point in time, we could actually go into the specifics as to his order. So let's go ahead and take a look at what he has filed. Here we have the judge's order denying motion for judgment on the pleadings. I don't think it's going to be a very long order. There are a few ancillary documents, so it won't be super short video, though it still will be short in a sense. the introductory paragraph looks pretty standard. He mentions that he reviewed my motion, that there's no opposition or response. By the way, guys, most of the appeals that I win, that these judges get dinged on, it's because they deny unopposed motions. I think I've talked about this before. When they do that, they really better have their stuff together. You know, maybe I'll talk about this more when I start winning those appeals, and I'll explain why it's very risky for a judge to deny an unopposed motion. There's actually quite a bit that goes into analysis of this kind of stuff on appeal, but when the court denies something that's unopposed, the Supreme Court will actually block off the person who didn't oppose it from even participating in the appeal. It doesn't mean you're going to win automatically, but it really does disadvantage the losing party, or I guess you could say the winning party, because they're the ones that won without even having to file anything. In any event, we'll talk about that more when that actually comes up in the series. My ex did not file an opposition. The government did not file an opposition, but the judge still denied it. And it just ties into what I was talking about earlier with self-representation bias. So, procedural history, he mentions that we share a common minor child. Order after hearing, we share joint legal, joint physical custody. Let's go to the next section here. I filed a petition for judicial review. The Secretary of State, I was trying to get the Secretary of State to disclose the address that my ex provided. The request was denied by the district court. The Supreme Court affirmed. However, I filed an original petition for writ of mandamus, and this time the Supreme Court published a decision, and that decision contains a framework. Based on the direction from the Supreme Court, I filed a petition for writ of mandamus in this case, and I'm trying to get this court and this judge to issue a writ commanding the government to turn over my ex's address. Next is that an order was entered on July 1st requiring us to set the matter for an evidentiary hearing. According to my case, Falcone v. Secretary of State, the court finds it necessary to hold an evidentiary hearing to determine whether my ex can establish whether I was a perpetrator of DV. Additionally, the Secretary of State and my ex were ordered to file a response to the petition. In the response to petition for writ of mandamus, the Secretary of State asserts that it correctly issued the fictitious address to my ex based on the law, and that the temporary protective order provided to my ex was consistent with the law. Secretary of State asserts that it has no interest in these substantive questions and does not take a position regarding these issues in this proceeding. The court notes that my ex did not file an opposition or a response. The matter was set for an evidentiary hearing on August 19th. Pursuant to local rules, the case was transferred to this judge. And I've talked about this before, but this is the one family, one judge rule. The judge, District Judge Patrick Flanagan, vacated his hearing, transferred the case to District Judge Chuck Weller, and the hearing was not reset. Motion for judgment on the pleadings. In my motion, I'm asking this court to render a decision on the pleadings. I note that the Secretary of State filed what essentially amounts to non-opposition, and my ex did not file any response. I state now that under the law, petition for writ of mandamus cannot be granted by default. I argue that based on Department of Motor Vehicles v. Rebol, that it is proper for a court to render a decision on the papers. I don't know why he's putting in quotation marks like this. That's exactly what the Supreme Court said, because it's a decision based on the merits, which is true. Guys, if you want to see if this is true or not, read the case for yourself. What happens in this case is exactly the mistake that this judge makes. This judge basically tripped over the same rock. In that case, the Supreme Court of Nevada stated, yeah, the government didn't participate. However, reading the paperwork and making a decision based on the paperwork is the decision on the merits. This is not a strange, totally out of the blue notion. It's totally normal. I'm alleging further that, based on Falcone v. Secretary of State, my ex has the burden of proof, which she does. Motion for judgment on the pleadings is designed to provide a means of disposing of cases where material facts are not in dispute, and a judgment on the merits can be achieved by focusing on the contents of the pleadings, which is exactly what's going on now. An order granting judgment on the pleadings under local rules is appropriate only when material facts are not in dispute and the movement is entitled to a judgment as a matter of law, which is exactly what we have in this case. I have alleged a series of facts. My ex has not controverted them. The government has not controverted them. The facts are not in dispute. Specifically, in Falcone v. Secretary of State, the court concluded that, as a co-parent, I can seek disclosure of my ex's address in the district court by extraordinary writ, and in determining whether to grant it, the court must consider whether my ex can establish that I was actually a perpetrator of DV. It is the public policy of the state to decide cases on their merits whenever possible. If the opposing party fails to serve and file an opposition, the district court has the discretion to construe that failing That failure as an admission that the motion is meritorious and a consent to granting the motion. Going into the next section here. Local rules provide that a decision on the motion shall be rendered without oral argument unless oral argument is ordered by the court. So he's basically trying to say that there's a number of discretionary areas of the law where he can go ahead and do what he's doing here, which is to allow us to proceed. But what he's wrong about is there's a difference between filing something late and not filing something at all. And I already talked about this earlier in the video. The problem with her not filing anything at all is I don't know what her assertions are. And you're not allowed to go in and basically conduct a trial by ambush. And this is something that most attorneys know. I would say probably all attorneys know. And it should be all judges that know this too. So I get what he's trying to do. I know that he's citing local rules, but this isn't something where my ex filed the incorrect piece of paper or my ex filed a piece of paper late. She didn't file anything at all. So allowing her to do this is prejudicial to me because I now don't know what it is that I need to bring to court. I can guess. There are a few things I can imagine I'll probably need, but until I know exactly what her assertions are, I won't be able to conduct the best possible defense. Luckily, she doesn't show up at the hearing anyway, so it's not going to be a big deal. But I'm just letting you guys know that what this judge is doing is not cool, and you should think very carefully about allowing a judge to do this to you. Anyway, I talked about it earlier in the video, so I'm going to proceed now. Pursuant to specific direction from the Supreme Court, he needs to make a factual determination, and he orders us to appear for an evidentiary hearing. Conclusion, based on the aforementioned reasons, he denies my motion. The court finds it necessary for the parties to appear for an evidentiary hearing. Therefore, I shall file within 10 days notice to set. And the same stuff that I've already done before in the series is just file a notice to set, go through the procedure, set a date and time, and show up to court on that date and time. By the way, guys, I am pretty sure we have another hearing video coming up in... I think it's 3 videos from now, but it might be 4 videos from now. Again, like the last video I do, or like the last hearing video, I do intend to premiere it. I do intend to give you guys a heads up. I'll give you a specific date and time. I'll post something in the comments board on the channel. But yeah, it's not going to be as long. However, we've had a lot of fun watching these hearings together. So, I mean, even if it's going to be a short hearing, it'll still be a good time for us to all get together, watch together, and continue on in the My Docket series. Let's go into the next page. Certificate of service by mailing under Rule 5. Mails it to me, mails it to my ex, and he serves the government electronically. Next paper, notice to set. And we have set a date and time for the hearing. This piece of paper I have said a number of times before, though it hasn't come up very often, so I'm going to go ahead and bring it up again. This process is crucial. You have to understand how it works. I dedicated an entire video just to the notice to set. If you have not seen that video yet, please watch that video. You're only doing a disservice to yourself by watching the My Docket series and not stopping to watch these side tangent videos, because there's a lot behind a lot of this stuff, even though it doesn't seem like it, because this is like it's a 2-page piece of paper, so it seems like it's not that important, but there's a lot behind this. In any event, the next page is a Rule 5 certificate of service indicating that I am serving this to my ex and the government. Next document is notice of hearing. So it looks like myself and who else showed up? Does this mention it? Doesn't mention it, does it? No. Sometimes the person that files a notice of hearing will mention who showed up at the notice to set, but this one doesn't discuss that. In any event, we have set a hearing. That hearing is set for November 22nd, 2013 at 9 a.m. And I remember off the top of my head that the government participated in the setting, but my ex did not. So I showed up, the government showed up, my ex didn't show up. Between the government and I, we picked this date and time. Next document is another notice. What is this here? Okay, this is filed by the government. The government, okay, hold on a second. What is this? Notifies the court and parties of the expiration of the confidential address. Okay, so this is what I was talking about, I think 2 videos ago. Facts asserted. My ex first became a confidential address program participant on September 10th, 2009. Pursuant to the law, her fictitious address was canceled 4 years after the application was approved. Okay, I see. The fictitious address shall be canceled 4 years after the application is approved unless the participant renews the fictitious address before its cancellation pursuant to the law. Secretary of State's office sent notification of the impending cancellation and a renewal package to my ex on August 6th, 2013. A second notice was sent on or about October 1st, 2013. To date, the Secretary of State has not received a request for renewal from my ex. The Secretary of State's office therefore canceled her fictitious address effective September 10th, 2013. Affidavit of Janice Stokes attached here too as Exhibit 1. I'm going to go ahead and take a look at that. Discussion. Cancellation of the fictitious address does not moot this case. Interesting. See, guys, I mentioned when I first covered this video that the government's attorney really presented to me a sharp contrast to all of the other attorneys that I have ever, interacted with, not only up to this point, but even ever since then. And a lot of times, attorneys will abuse the mootness doctrine to confuse the court. They will say things are moot when they're not moot. This is an extraordinarily common tactic. It fits right into what I talk about in the video, Win at All Costs. It is one of the easiest ways for a conniving or a deceptive attorney to confuse the court into making a legal mistake. Mootness is something that judges don't fully understand. There's quite a few pieces to that puzzle. I think I have a video dedicated to the mootness doctrine. Definitely take a look at that video if you haven't seen it yet, because it was used against me multiple times by my ex's attorney. In any event, this is an attorney who could very well do the same thing that all the other lawyers have ever done that have gone up against me, but he's not doing that. He sets himself apart. He's completely different from the other attorneys. He's actually saying that the case isn't moot. Totally probably shocked me to read that. I was just probably like, whoa, it's the first time I've seen that. In any event, he is saying that the above facts should be brought to the attention of the court and the party. I'm going to read this again. Undersigned counsel feels that the above facts should be brought to the attention of the court and the parties. The cancellation of my ex's confidential address does not alter the confidentiality of the records. And then he goes in and he discusses the statute here, which explains the fact that the secretary is still required to keep that address concealed. The protections under the law have no time limit, nor does the law permit disclosure of records once the fictitious address is canceled. The pertinent part of the statute is subsection 1, which states, except as otherwise provided, the secretary shall cancel the fictitious address after 4 years. Cancellation of the fictitious address only has the effect that the fictitious address designated for that person by the Secretary of State is no longer going to serve as that person's address. That's the only effect that it has. Secretary is no longer required to forward mail to the person. However, under the same law, the secretary cannot make public any of those records. So it's almost like he's arguing on my behalf now, because of course I want the case to proceed as well, and I want to know what that address is. So it's really nice to see this brief filed by the government. Hopefully it's a jarring brief that gets this judge to realize he's the only one in that boat. He's all by himself floating around in this boat that's trying to, justify the issuance of this fictitious address. We're going to show up at the hearing. He's going to see that nobody's going to argue on her behalf, and he's going to have no choice but to issue the writ. In any event, let's proceed. We have the affirmation pursuant to the law indicating that this document does not contain the social security number of any person. And here we have the certificate of Rule 5 service indicating that he has mailed this document to both myself, my ex's attorney, and my ex. Or I guess all 3 people. Okay. Exhibit index. Exhibit 1. And here we have the affidavit of Janet Stokes. Number 1, she's employed by the Secretary of State's office as an administrative assistant, level 3. In that capacity, she is responsible for overseeing the records and operations of the confidential address program. Number 2, based on a review of the records, my ex first became a participant on September 10th, 2009. Number 3, pursuant to the law, the fictitious address shall be canceled 4 years after the application is approved unless my ex renews the fictitious address. By the way, guys, I want to stop right here and tell you, this is not a 99% chance. If I did not do what I did, if I did not go all the way to the Supreme Court and get this publication, 100% for sure, without question, without a doubt, my ex would have filed to renew this, not just once, but all the way as long as she possibly could. She would definitely have done that. And I can tell you this with absolute 100% confidence because she used this all the time. She was telling teachers about her confidential address. She was telling doctors about her confidential address. She was telling the Discovery Commissioner about her confidential address. It was like a badge of pride for her. She waved it around like a flag. Everyone who was involved in anything regarding our son knew about the confidential address. The only reason, 100% for sure, without question, without a doubt, that she did not return their calls is because of the writ that she knew was going to issue. She knew that this hearing was coming, and she knew that she had nothing to show that proves any of the stuff that she was saying, any of her allegations are true. Not only did she have nothing to prove after the fact, but if you go back to I don't remember now, I think it's part 2, maybe it's part 3. Early on in the My Docket series, guys, way back to the early, you can watch that hearing video for yourself. And even at that hearing video, when she testifies to the domestic master, even at that point, her allegations didn't reach the point that it needed to show that she was an actual victim. The only thing she could allege was that I might, maybe, possibly one day do something purely speculative. In any event, I just want you guys to know that this isn't something that was just going to happen on its own anyway. This was not going to work itself out. This is not a 50-50, an 80-20, a 99-1. I am 100% absolutely sure about this, just based on the fact that any opportunity that she possibly could, she brought up this address to anyone and everyone who was willing to listen, who was involved in our case. So let's continue on. On or about August 6th, this administrative assistant sent a renewal packet to my ex with the information. So they even sent her the information and the packet. On October 1st, she sent a second notice that the address was expiring. She also left a voicemail message. I want to stop here. I highly doubt that this is what they do for everyone that's in the program. Most likely, they knew that they were in the Supreme Court of Nevada and that a hearing was coming up on this issue. And most likely, they went above and beyond. They didn't just send her one packet. They didn't just send her two packets. They called her and left her a voicemail message. To date, I cannot imagine them picking up the phone and calling up every single CAP participant. I don't believe it. In any event, number 6, to date, my ex has not renewed the fictitious address. And number 7, on or about October 10th, this administrative assistant sent her a cancellation letter notifying her of the cancellation of her fictitious address. Going into the aftermath, I filed, it looks like, two documents. Yeah, that's right, 2 documents, but they were free filings, so I incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex did not file any documents, so she incurred $0 in costs. My ex's attorney stated that she wasn't going to participate in this proceedings, so she incurred $0 in attorney fees. I assume she's receiving these documents, but I'm not going to tax her for time on any of them because she most likely didn't do anything with them. And then we have the government's attorney. He filed 1 notice, but it was a free filing, so he incurred $0 in costs. And let's see. So the notice of hearing, I'm sure that was in his records. He probably had the date and time just from the notice to set alone. So I'm going to put that at 0 minutes. The notice that he prepared, that's going to take a little bit of time. There was quite a bit of detail there. There was an affidavit there as well. I feel like 15 minutes is way too low, but I feel like 45 is too much. 30 sounds reasonable. So 30 minutes for that notice. And then we have the notice to set itself. He would have needed to prep for that, schedule that, and participate in that over the phone. So I think that might be another 30-minute document because of the amount of time. I don't know. 15 minutes is possible. Let's go ahead and say 15 minutes. So we got 45 minutes total so far for the government, and then we have the order denying. That order doesn't require any work for the government, though ironically, later on, it will require him to show up in court. So that there is going to be a waste of Attorney General resources in this case, but it does not occur yet. It will be coming soon. So that's another 15 minutes, I think, for him to just review that order denying. That's going to take the government's attorney fees to an hour, which at the rate of $250 an hour comes to $250 in attorney fees for the government. As with my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.